Hi, this is John Farrell of the Farrell Law Firm. I'm an estate planning lawyer and author of Estate Planning for the Modern Family. Estate Planning for the Modern Family is a book that will help you learn what is involved with a Georgia last will and testament, why a power of attorney is just as important as your will, and how to plan with advanced estate planning techniques such as trusts. And so I get very good questions at my office, and one of the questions that I get that I want to answer today is, which is better for you, a last will and testament or a revocable living trust? Those are the essential two primary estate planning documents that people use these days. There's many other more complicated things, estate planning vehicles, but those are the two primary ones, the last will and testament versus the revocable living trust. Now, for some families, especially young families with very young children, a last will and testament and disability documents may be all you need in your estate plan. However, most families with teen or adult children fare better with a slightly more advanced, multifaceted estate plan. And so one of those primary vehicles they use is called a trust. Now, trusts offer many benefits and can be a great way to protect your estate and provide for your loved ones. One of the main reasons that people like trusts and that trusts are so popular these days is because they allow you to avoid the probate process that is required to carry out the terms of a last will and testament. And so why do people want to avoid probate? Well, the typical answer is it is often a lengthy, stressful process, and sometimes expenses can run high. While all probates are different, every probate takes between several months to several years to complete. It often involves multiple court filings. Every time one of these documents is filed at the courthouse, it must be stamped and typically will undergo review by a law clerk, get signed by a judge, and go back through the processing department before it's finally available for the family. And those things just simply take time. On top of that, there's potential for other types of delays. I hear people complain about attorney delays, courthouse delays, paperwork processing delays, financial institution delays, and from other people that might be involved in the process. If everyone involved in the process isn't going to be proactive, and they're not in complete agreement on how the process is going to go, then they can file what Georgia state law refers to as a caveat, which will basically shut down the probate process until the court can figure out what's going on and then force the probate forward. Regarding the costs with probate, every probate is different. You've got different heirs, different issues, different underlying assets, different complexities. But once you factor in things like court costs, attorney's fees, executor compensation, maybe miscellaneous costs like getting the house appraised, probate costs can range all over the board. I've seen it from the thousands to the tens of thousands of dollars, depending on the matters issued with the probate. Now, don't get me wrong, Georgia is not a bad place to probate a last will and testament, especially if you're going from spouse to spouse. But even then, if the property isn't titled correctly, it can sometimes be problematic. But it's not that bad. Again, it usually just takes several months, and hopefully it won't go a year, but sometimes it does. So, it's not as bad as many other states. So one reason that someone might want to incorporate a trust over a last will and testament is because the trust will avoid the probate process. Second reason someone might be interested in going with incorporating a trust into their estate plan is because you might be a private person. Perhaps you don't want the public to know what you have and who's getting it. But when a will is filed with the court, it becomes available to the public, and trust can help you keep your family's business private. Trust can accomplish keeping your affairs private. Unlike wills, trusts aren't filed with the court and therefore never released as public record. In my practice, I also help people probate wills, and I can go online, and you can go online. You can search up people's wills after they pass away and really see everything about them. And in this particular county where I practice, they're all online. I don't even have to leave my office to see them. So The question of whether a last will and testament or a revocable living trust is better for you kind of depends on a few things. If you are a young family with young children, you don't have a lot of assets, you don't mind the probate process, then a last will and testament could very well be what you need. But if you're a little bit older, maybe your children are older, maybe you've got some assets like a home and maybe more than one home, maybe you've got a vacation home, especially in another state, then you might benefit from something more complicated, multifaceted, like a revocable living trust. Okay, so those are some of the factors to include on whether a revocable living trust or a last will and testament is better for you. Of course, it's better to consult with an experienced estate planning attorney when you're trying to decide between those, and they will help you get to the place where you can decide which is better for you. If you have any questions, don't hesitate to email me. My email is listed on the screen here. I'll be glad to answer any questions that you have, and who knows, you may end up in next week's video about the great question that you've answered. So I appreciate it. Thank you.